International law has been regarded by the international community as a means to ensure the establishment and preservation of world peace and security. Peaceful settlement of international dispute is a fundamental principle of international law. It is formulated as such in the UN Charter and developed in UNGA Resolution on Principle of International Law concerning friendly relations and cooperation among states. Diplomatic methods of dispute settlement are negotiation, inquiry, mediation, conciliation, and good office. Negotiation is a method by which people settle difference. It is a process by which compromise or agreement is reached while avoiding argument and dispute. Negotiations are used in many situations such as international affairs, the legal system, government, industry dispute, or domestic relationships. Negotiation is a flexible means of peaceful settlement of dispute in several respects. It can be applied to all kinds of dispute, whether political, legal, or technical. It is aimed to resolve points of difference to gain advantage for an individual or to craft outcomes to satisfy various interests. It often conducted by putting forward a position and making small concessions to achieve an agreement. Now we move to the cases which is the crime of genocide that arose between Bosnia-Herzegovina versus Yugoslavia. The Republic of Bosnia-Herzegovina has instituted proceedings against the Federal Republic of Yugoslavia, which is claiming that the latter were responsible for the commission of genocide in Bosnia-Herzegovina. Bosnia-Herzegovina also requests provisional measures to prevent ongoing genocide. The court has made two decisions indicating provisional measure in April and September 1993. The inability of Bosnia-Herzegovina sufficiently strongly to fight back against the Serbs and effectively to prevent the implement action of the Serbian policy of ethnic cleansing directly attribute to the fact that Bosnia-Herzegovina has directly access to weapons and equipment that has been limited by the embargo. Embargo has led to the imbalance in the possession of arms by the two sides, and that imbalance has contributed in the greater or lesser degree to genocide activities such as ethnic cleansing and elements of law. The genocide is jus cogens, and a resolution which becomes violative of jus cogens must become void and legally ineffective. There may be advantage for Bosnia-Herzegovina in being able to say that the court had identified a source of doubt regarding the validity of the embargo resolution, which, though not directly operative by itself, but requires that the Security Council give the matter further consideration.
Moving on to inquiries. Inquiries have been used as a part of the other method of resolving the dispute. They provide a permanent name group from which all parties can select committee members. The task of the investigation committee is to clarify the fact through fair and serious investigation in order to facilitate the settlement of dispute. The parties are not obligated to accept the result of the investigation. However, they will always accept them. In the practice of international organizations such as the United Nations and its specialized agency, the use of inquiries is obvious. Next is mediation. Mediation use respected third party called a mediator to resolve a dispute. The mediator does not have the legal power to force acceptance of his or her decision, but it depends on persuasion to reach an agreement. The mediator acts as a natural third party and facilitates rather than direct the process. More specifically, mediation has the structure, timetable, and motivation that are lacking in the conventional negotiation. The process is private and confidential and may be enforced by law. Participation is usually voluntary. This is more peaceful and internationally accepted solution to end the conflict. Mediation can be used to resolve dispute of any size. Much depends on the skill and training of mediator. Adjudicative method of dispute settlement. This method is preferable because they obligate to follow the decision that have been fixed for them, and it's not just recommendation as in the cases of diplomatic method. In this method, it consists two types of procedure, which is arbitration and judicial settlement, where both procedure involve the determination of different state through legal decision of tribunals. For arbitration, it is referred to the adoption of other courts. The United Nations Charter retained the same distinction, but the International Court of Justice replaced the Permanent International Court of Justice. Arbitration is an effective and widely used method for resolving a dispute. It is one of the several types of alternative dispute resolution, and it provides parties to dispute with alternative to litigation. The arbitration is conducted out of court. The parties choose a fair third party called the arbitrator that will agree in advance to abide by the arbitrator ruling. So then, participate in the hearing and both parties can provide evidence and testimony. The decision of the arbitrator is usually final and the court rarely reexamines the decision. In the case of judicial statement, the ruling is made by a permanent court such as International Court of Justice. The ICJ is the most important international tribunal because of its both prestige and jurisdiction and principal judicial organ of the United Nations. All members of the United Nations are ipso facto parties to the statute of the court. The judges of the ICJ are appointed by the United Nations, not by the parties to a dispute. The ICJ has to apply the rules and principles of international law, which are enumerated in Article 38 of the Statute of the Court, where the parties have no choice in specifying the rules to be applied by the court. A good example in the case of Aegean Sea continental shelf, Greece and Turkey. On 10 August 1976, Greece started proceeding toward Turkey in the disagreement over the Aegean Sea continental shelf. Greece claimed the right with the arguments such as Greece is the country composed by the continent and island, and that it should not enter a foreign sea between this political and territorial integrity. However, Turkey did not accept the claim form of Greece and desired that must resolved by the international judicial institution of dispute. Greece sent a request to United Nations Security Council and International Court of Justice. United Nations Security Council invited both sides to consider the issue and taking it to the court.
Institutional methods of dispute settlement. This kind of method involves the resort to international organization for settlement of international dispute. This method has some come into existence with the creation of the international organization. The most eminent organizations that provide mechanism for settling dispute between their member states are the United Nations and the regional organizations, such as the European Union, the Organization of American States, the Arab League, and also the African Union. In this case, Nicaragua brought a suit against the United States on the ground that the United States was responsible for illegal military and paramilitary activities in and against Nicaragua. The jurisdictions of the International Court of Justice to entertain the case as well as the admissibility of Nicaragua application to the ICJ was challenged by the United States. Although the question of jurisdiction and admissibility are primarily based on the principle that the ICJ has only power as much as that agreed to by the party, this can be quite complicated. The 1946 Declaration of the United States and the 1929 Declaration of Nicaragua was the main focus of the case on declaration, and each of these declarations points out that respective party intends adhere to the ICJ jurisdiction. At this point, Security Council may recommend appropriate procedure or methods of adjustment. If the parties to a dispute fail to settle it, they shall refer to the Security Council. Furthermore, should be the Council itself deem that the continuance of a dispute is likely to endanger the maintenance of international peace and security, so this case has to third party to settle it, which is the international methods of dispute settlement. In conclusion, based on these three main cases, the main question is, how should we choose the suitable means of settlement? Before trying to answer that question, it is perhaps worthwhile to underline certain observations. We know that international law imposes an obligation to settle dispute by peaceful means, but unless the parties have agreed otherwise, there is no obligation to resort to a specific mechanism. Clearly, the peaceful settlement of international dispute is an important idea that many international diplomats, lawyers, and commentators aim for. However, while in a perfect world the use of law would be the means of resolving dispute, we know that in reality it is political and economic factors that so often take precedence. Nonetheless, law or international law can play a significant role in some dispute. Thus, while we need to be realistic in acknowledging the limited role of law play in many disputes, at the same time, we should never underestimate and we should be an advocate in favor of the powerful potentials of law.